5 minutes left, everyone. Well, on Zoom, we have 5 minutes left. We'll go through the questions at 2:30. All right, that's it, everyone. Okay, that's fine. So what we're going to do is okay, before we get started with going through the questions, can I just get a show of hands question? Just how do you find this paper so far? Who thinks it's easy? Show of hands. No one. Pretty simple, yeah. No? Yeah. Who thinks it's moderate? Like pretty decent. Yeah. 1, 2. Who thinks it's hard? Which is harder, section A or section B? Section B is harder because I haven't done them yet. Section A is harder. Okay. Well, what area do you find it hard exactly? Right. Okay. Anything else that you guys find difficult? No. Timing wise, it shouldn't be an issue because in the actual exam you have 20 minutes to do 10 questions. So I give you guys 20 minutes to do 20 questions with all this research and stuff. There are also some very strange, basically two types of questions. One is content questions. The other one is like problem scenario where I talk about my history working and then stealing a fuel container, or talking about some random cases here and there, talking about a student who evaded fares because of my key, all sorts of things, or punching tutors because of foundations of law exam failing, that kind of things. Two kinds of questions. So obviously the problem scenario will take a bit more time. There are also a lot of questions that has you tricky legal principles. So what I will do is I will get you guys, okay, so because there is a top prize, I will be giving a top prize. So if you want to participate in this top prize, then I will get you guys to change your work with another person to mark it. If you don't want to, then you can mark it yourself, but you won't be eligible for the prize. All right, so you can change with your same table, or you have no one, you can pass to me. But ideally change with someone else, yeah? Can you pass to me? Okay, then you can grab
The
this.
warning. Okay, I've got like a trigger warning here. Like I only have studied up to like here.
Yeah.
So everything onwards is probably bullshit, and I missed it.
No worries.
Good luck.
All right, there you go. Anyone else wants to pass to
I
me?
look at my phone.
Yeah? No? You can pass to me if you don't want to pass to friends as well. No? All right, let's go through. And make sure you have a copy of the paper as well. Yeah. Yeah, you need to have a copy of the paper as well. I'll give you this one. You can take this one. Yeah, just make sure you know, okay? Yeah, but I'm going to trust you guys, all right? So don't change your answers. Naughty. I will sue you at the court if you do that, okay? So it will be a civil case, not a criminal case though. So first two questions pretty simple. If you get a different question, different answer, just let me know if you have any questions along the way. First question, the rape is a sexual offense. The offense carries maximum penalty. Okay, the first sentence is just context. It does nothing. You'll be like, I didn't study rape. Yes, you didn't study rape, but it's just a context. Who is responsible for enacting the law is the question. So the parliament is responsible. Answer is C. The High Court sentences people, the Supreme Court sentences people, the police doesn't do much. Anyway, question 2. Which of the following factors make sentencing more demanding for judges and magistrates? Answer is B. Sentencing is complex and there may be conflicting factors to be considered. Any questions on this one?
Just a question on the one before. What's the difference between High Court and Supreme Court?
So Supreme Court of Victoria is in Melbourne. High Court is in Canberra. They are high hierarchy. Yeah. So for example, if today after this lesson you get charged with murder, you go to the Supreme Court and you're not happy because you got sentenced to life imprisonment, you might want to go to the High Court to appeal it. All right. Next question. Question 3. Law student got a car theft against him in Melbourne. Statute-based information. So that means that all those Victorian Sentencing Council doesn't matter at all because you're looking at statute. So statute will be Crimes Act 1958. Answer is C. A certified barrister and law institute of Victoria, they're not statute-based again. All right. Question 4 test asks about section 5 of the Sentencing Act. So A, B, C, D, E, F. I think there's like 6 of them listed. The answer compensation is not part of that purpose. Answer is D. I believe most of you when I walk around got this correct. Next question. Next question is pretty interesting. Which of the following is most difficult to sentence? What's our interpretation of this question? like when we say most difficult to sentence. Because there will be some vagueness and workaround. There are people who are not too sure what is most difficult, what is higher in hierarchy in sentencing. Like when we think about this, obviously you can't clarify for anyone during that actual quiz that you have in class. I mean on your own laptop. So a reasonable judgment, most difficult, I would interpret it to be takes the most amount of time, takes the most amount of energy, takes the most amount of resources. So first of all, a speeding offense by Monash Uni student who's late to class, pretty simple summary offense. You get the ticket, you're done. Student who did not pay his school fees, answer D is also is a silver kind of not that important kind of things. There's no sentence in that. So I see a lot of people choosing between B and C. The answer is C, a student who shot a gun at his professor for failing the foundations of law exam. Why? Because this is likely going to be an inductible offense under section 16, intentionally causing serious injury. If the professor died as a result, it might be homicide. In contrast, a student who evaded fares, what's going to happen? The mighty officer might come to you and fine you and give you a $288 ticket. You can appeal it, you can go to the Facebook group and complain all sorts of nonsense that you want, but you're not going to get sentenced. Or you go to the magistrate court every Thursday at 2 p.m. Don't ask me how I know this. They sentence all the mighty fare evaders. It lasts 5 minutes. Contrast to if you shot your foundations of law professor, it's going to be a very serious offense, okay? Question 6, which of the following describes the term instinctive synthesis? Answer is C, option 1, 2, and 4. A court will first identify all the relevant factors, weigh its importance, and make value judgments. All right?
Yeah.
You're fine, I see. Question? Why is it not D? Because the court, all humans have instinct. It doesn't make sense to use instinct to make judgments. Therefore, we don't need lawyers if we use our instinct. Yeah. All right. Question 7. If you're not a lazy person, you should get the answer. Answer is C. Even if you don't get it, I'm not saying you're a lazy person. You just have to go to the Sentencing Act to get the answer. All right. Don't get offended by me. Question 8. A lot of people try to ask me, who is considered higher, what is considered higher in the sentencing hierarchy? This question, first of all, this question is actually taken from what is it, your Monash model. One of the questions asks you, which of the following is lower in hierarchy? I changed it to higher in hierarchy. The idea of higher and lower, just higher just means more severe. Lower just means less severe. That would go under the common interpretation. At least that's what your faculty interprets that to be. So I will go with that interpretation. Answer will be D, imprisonment. Okay. All right, let's go on to question 9 again about Aaron receiving a speeding fine. I hope no one calls Aaron over here. I'm just randomly jumping names here and there. Oh, we have Aaron? No, we don't. No. All right. So he decided to go to court. Okay, which of the following is incorrect about the court hearing? So during the court, again, I believe a lot of the traffic offenses are heard on Thursdays at the magistrate's court. Don't ask me why, I just know them for some reason. Anyway, he goes to court, he could plead guilty or not guilty. It lasts about 5 minutes or so. The magistrate is going to ask you, okay, tell me what happened. Oh, Your Honor, I ran through a rate, like, oh, Your Honor, I speed at Dandelion Road, okay? And I said, why did you do so? Blah, blah, blah. I was running home trying to get a burrito. I was really hungry after work or whatever nonsense you say. Then you say, okay, do you plead guilty? Yes, I plead guilty. I promise I will not commit this offense again. Then the magistrate will say, all right, fair enough. I understand your situation. Okay, your case is dismissed. Go away. Something like that. Okay, so he could plead guilty or not guilty. So therefore, it is important if he pleads guilty or not. What if he pleads not guilty? The magistrate will say, okay, we've got evidence here. Tell me, why are you pleading not guilty? All right, this fine increased to $1,000, for example. Okay, so the answer will be B. Okay, whether or not he pleads guilty or not is still very important. Question 10, answer is D. The accused or defendant pleads guilty is important because we need to have information, especially when the defendant pleads guilty. If there's already been a trial, it's a high-profile case, or they plead not guilty, the trial will go on, they will probably uncover the facts a bit more. All right, so that's for section A. Question? Yeah.
Like if he knew that he was student.
He wasn't speeding, and there was,
But he wouldn't get caught in the first place.
Sorry.
Or like, if you know time is faulty and you weren't hit by a car. Or like, do you mean like, he knows that he's wrong?
I mean, either or.
yeah, if he can prove that, then he would be fine.
Oh, we should have.
Correct, yeah. Question at the back?
For question 10.
Yeah.
Wouldn't it be more important, like, or all the information be more important when it's not guilty, because you have to use all the information to prove that they are guilty?
Yeah, so if the question says informing the court fully.
Yeah.
Yeah, so when you plead guilty, you have to inform the court of whatever that's been done. The court will find the information themselves or uncover if they're not guilty. Option C is similar to like option A, where there has been a trial or something like that. Fair enough. For example, let's go back to question 9. If you got the speeding fine, you plead not guilty, what happens? The magistrate is going to show the camera, show the readings. They are informing you. But if you plead guilty, you explain to the magistrate what happened. Okay. Go on to section B. We'll be going a bit faster. Question 11 is D, pretty simple. This is from Fagan. For all offenses, no, sorry, not from Fagan. For all offenses, AR and MR must be contemporaneous. That's wrong because there are some absolute offenses, such as street liability, running through a red light kind of things.
Yes, questions I forgot to answer.
Yeah, no worries.
We go to C.
All right. Okay. All right. You really want that jumper, don't you? No. All right. Question 12. The Latin phrase answer is A. Guilty person, guilty mind, right? Question 13, answer is C. The idea that actions of the accused who has a guilty mind may be in some cases be legally justified. Right? Question 14. Answer is A. The prosecution must prove guilt of David beyond reasonable doubt. Question. Which question is that? 13, yeah. Yeah, so it says the idea that the actions of the accused who has a guilty mind may be in some cases be legally justified. May be. Why can't it be B? The act that a criminal act may occur without intent. Yes, so which idea is missing from the maxim? So the maxim itself encompasses this idea that you need AR and MR to be together for a guilty mind. So the act has the maxim has sort of this element within it. Okay. It's a little bit confusing, I know, for that one. Question. That's just from your understanding of this term, just general understanding. Also, that I believe this question I did got that if I think an inspiration from Moodle as well under at topic 3, there are some future explanations for that as well. But pretty much the idea is that this element is missing. Option B is not. Option B is being encompassed by that phrase. All right. Question 14, beyond reasonable doubt. That's a pretty simple question. Answer is A. The last 5 questions prove some difficulty to students. Let's go to question 15. Right? 15 tests you your understanding of the term of the case Hallett. Okay, in Hallett we have the tin skull rule. Those who use violence must take the victim as they find. Option is D. Okay. Questions on 15? No? All right. Let's move on to 16. 16 tests your understanding again in causation, novus actus intervenes. In the LSS sketch notes, I put in 3 categories where there is a possible novus actus intervenes. Act of victim, if they're unreasonable, act of third party, an act of God. So the answer is act of defendant is not a novus actus. How can you doing something? You took the gun and you shoot the person, you say the actions of myself, I'm the defendant. It's a form of action that brought the chain of causation. It doesn't make any sense at all. All right. Question 17. D went on a hike and saw V, who was weak and fainted. To avoid trouble, D walked away and did not do anything to save V. Oh my God, very bad person. Morally blameworthy. V later suffered injuries and tried to sue V. Tried to sue D for his actions. Sorry, there was a typo again. Which of the following is one way that D could argue to avoid himself from legal liabilities? I see a lot of students choose C. C is incorrect. There are negligence when there are certain sort of liabilities in negligence, like negligent homicide. Okay. For example, if today, question 19, if I burn down this place, some of it died, I am negligent, but I will be liable. The answer is B. There was no positive and voluntary act. Okay. Question 18. Which of the following is incorrect about the rules in Fagan and Metropolitan Police? Okay, this question, some of you, okay, answer is not A or C, obviously. People struggle between B and D. This question, you can either do two ways. You could either obviously go to the notes and check for whether this statement goes through that 300 pages of judgment, or you could do this question from basic principles and understanding. Your understanding from Fagan should tell you that even if MR is not present at that moment of your action, it could be superimposed. Okay, so the idea that D, which says that a mere omission cannot amount to an assault, is incorrect because it is necessary that MR should be present at inception. The common law does not allow the superimposition. Okay, so the answer would be B. That's incorrect. The common law allows. All right. Question 19. Question 19 is a variation of what we've done in our tutorial classes. Previously I did was GYG, I believe. Today I changed it to my name. I'm not a car mechanic, by the way, but yeah, I'm not a car mechanic. Anyway, so the idea between B and C, the answer is C, is negligence. B requires a foresight of probability. If you think about this, intention, most morally blameworthy. Recklessness, somewhat morally blameworthy. Negligence, you just did not perform your duties of a reasonable person, and as a result, you cause some damages. You are not so much morally blameworthy. If today I walk in a car mechanic, I come back, bring fuel, I put it over there, and I spill it and there's a fire. Okay, it's pretty bad to be honest, but I did not intend, or like half of my intention, like recklessly caused that. I negligently done that action. Intention, reckless, negligence. All right. Finally, running through a red light, pretty much. It's pretty simple. All right, just add up your score. I will add up this over here, write it on the front page as well. Yes.
This one stopped me because last time we were thinking about a bottle where like the girl didn't know what was inside the bottle.
Yeah.
But whereas you're coming to like school with life, how is that not reckless? Is it because you didn't think about it?
I didn't think about it.
That it was a bias.
Yes.
But isn't that like mostly, because does the jury like infer that from you? It's like they have to prove that like you didn't think about the potential consequences, right? They have to like infer it.
I'll get back to you in a moment. Just let me finish this one and then I'll. Is that okay? Yeah. Just give me a moment, please. Give me a moment. Oh, just keep it to yourself, guys. Just keep it to yourself.
Yes, nope, nope.
Yeah, I'm guessing what
This is no. This is no. This is no. There you go.
only that.
There's no point in telling I got a 10, but he got 19.
Okay.
So
Who is
he's higher
Will?
than me.
Where's Will? All right, table obvious. Who here has got higher than 19? Who here got 20 out of 20? Who here got 19? Come out to me. One. Anyone got 19? Let me just check which question you got wrong.
The section, yeah.
You got the section wrong. Question 7.
Yeah, second guess myself.
Second guess is all.
Yeah.
All right. Anyone else got 19? No? Okay, I will come to me after the class. We can go to office together. But yeah, just take a seat first. But before that, we have one more question on question 19. Is that correct? All right. So could you just explain the question to the class again, please? Negligence, yes. 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 It's pretty bad. Yeah. They could. So what we do is we look at what the question already have in front of us. It says he accidentally hit the fuel. And obviously a reasonable mechanic would not have brought that flammable substance to class. It's really bad. He has severely fell short of the standard of care required of him by him coming to class. And that's the exact test for negligence. Okay, yeah, fair enough. Any more questions? No, if not, that's all. I wish you guys all the best. Next week, once we come back, we will start with our offenses against the person. All right, that's all.